So let me go to the second series hypothetical that deals with a woman is a lawyer. She has a stepbrother or something who's a jerk, and he's basically stealing money from her escrow account. She's got a lot of money in her escrow account. Maybe she represents Harvey Weinstein, I don't know. And there's a lot of money there. He siphons it off, and she is not exactly very cautious in how she runs the financial affairs of her law firm. Wonder if you can close that door, please. Thank you. So the district attorney finds out that the stepbrother has been stealing money from the escrow account, and they're investigating him. And she wants to make sure that Mr. Dopico doesn't ultimately come after her, or the DA come after her over her finances in her escrow account. And therefore, she decides to give the lawyer $250,000 to represent the stepbrother. And her lawyer's legal fee says it's a non-refundable legal fee of $250,000. And he puts in all the rest of the stuff that you put in a retainer agreement. Jorge, what about that retainer agreement?
Actually, we do deal with this quite often. Non-refundable clauses have been prohibited in New York, I believe, since 1994 in matter of Cooperman. It is now part of the disciplinary rules. You cannot have a non-refundable fee. Your client should be able to fire you at any point, get whatever money he or she is owed that you haven't, you're entitled obviously to be paid for what work you have done. You cannot have, and putting non-refundable in your retainer agreement is a huge no-no. We used to routinely admonish any attorney who did this. It gets a little more complicated because, some people, while they say non-refundable, they really meant a minimum fee and et cetera. So sometimes we'll do an advisement, but it's a huge no-no. You can't just say non-refundable. And you just had a case just like this, in a criminal case, huge, $400,000. They used the word non-refundable in a huge retainer agreement. So arguing back and forth, and eventually that case is going to get advisement, but originally had been recommended for admonition.
Has it been decided yet?
I believe so, yes.
And what was the result?
Well, it was going to be admonition. There were a lot of arguments. I'm going through it, and eventually it's going to be an advisement, which is a letter which is private. It's not disciplined, but the grievance committee will know about it, and if you do it again, we will know, and we will use it against the attorney ourselves.
Perry, if you were representing the lawyer who wrote that fee agreement that said non-refundable, but wanted instead to make it non-refundable but not say it was non-refundable or as close to non-refundable as possible, what would you do? What would you tell them?
I think two things. I think it's to really turn it into a minimum fee, and it's to almost compartmentalize it, to make it into a fee for a particular aspect of the case. So, for example, and we know sort of in the criminal defense world, on the defense side, that very often you have pretrial fees and trial fees. Okay, so one of the ways would be to charge a very specific flat fee for the pretrial stage. Okay, and it's deemed earned upon receipt. But of course, the challenge is what happens if a day later, or 5 days later, or before the majority of the work is performed, if the person is terminated. And so how we look then at a minimum fee provision, which is legal and it's proper, and you can charge, let's say, 200 of the 250, you charge 150,000 of that for the pretrial aspect. But what happens if you're discharged? That's the real issue, because there's nothing wrong with charging that as a flat fee and treating it in effect as though it's non-refundable. Problem is what happens when you're terminated.
Well, I can tell you, Perry, we're going to look at it. If you really, I don't care if you go a minimum fee, if it's really non-refundable and we think you made it non-refundable, we're still going to get your client.
As they say, a fee by any other name would still be a non-refundable.
And if you do a minimum fee, you have to really look at the rules, because you have to say very specific things you tell the client, that you have to look about it. It always becomes a problem, $400,000 minimum fee, client fires you the next day because they want another lawyer. Yeah. They want Joel Cohn.
Good choice.
He's the good one. And so now you don't want to give the $400,000 back. That's a big problem.
And I think that's, to Jorge's point, I think one of the things that both the grievance committee, but also us as ethics practitioners, when we look at this, first thing we're going to say is what's reasonable under the circumstances. And that's what the committee is going to look at. And if you're fired the next day, you got to give the money back. There's no question. You may be able to charge sort of and deduct on an hourly basis what you've already earned, but you're going to have to give the money back. The one place, I think the one exception that you see minimum fees and a non-refundable aspect, which I think is proper, is let's assume for a second on a Thursday night a client comes to you and says, there are motion papers due on Monday morning, okay, and they want to retain you. And you say, well, I'm sorry, I'm going on vacation to Europe with my family tonight. We will be gone for a week. And if you want me to do this for you, one, it's going to cost you $25,000, and B, I'm going to have to cancel my trip. And you say, once I cancel my trip, it doesn't matter whether you fire me tomorrow morning or Saturday morning or Sunday morning, because I am canceling my trip and you are retaining me basically for the next 4 days to do this work for you. That's an example of perhaps where maybe a minimum fee, almost a non-refundable fee, almost, is probably going to be okay because there's true consideration under those circumstances, but they're far and few between when you can actually do that. And most of the time, just using the word minimum fee, when we all know it's really a non-refundable fee, is still going to get you into trouble ultimately with both a client and the grievance committee.
What about the fact that some lawyers are going to be disqualified from other representations by virtue of getting this particular client, and then the next day the guy fires the lawyer, and then the lawyer is screwed, he can't represent any of these other people that would have otherwise come to him to represent them? Jorge, don't you care about us?
Sure, I thought you were asking Perry, but sure, I mean, that's one of the factors you can look at in doing a minimum fee. If you're gonna do a minimum fee, look at the rules, look at, what Perry was saying. The fact that you're giving up possibly other clients is one of the factors. The one thing I can absolutely recommend you is do not ever use the word non-refundable in your retainer agreement. Even sometimes we don't even really mean non-refundable, and it becomes such a huge problem for us analyzing then, did they really do it? We have another one to that, we have, and I understand this is since 1994, an attorney still putting non-refundable in the retainer agreements. Just sometimes comes up, this one case, this is great, this is the one I'm gonna do non-refundable. You can't do it ever, At least never use that word. I don't even like the fact the minimum fee, because sometimes I wonder what is a minimum fee, what is not a refundable fee. But you're allowed to look at some factors, and what Joel was saying, definitely the fact that you're giving up other clients that you could probably represent.
So
the fact that you were going to Europe and canceling a $25,000 European vacation. Oh, that's a nice vacation. Those are things that can be part of a minimum fee, and that'll be okay.
Would you put that kind of stuff into the agreement?
Absolutely.
So
And
you
in
would put
minimum
in that I'm
fees,
gonna
it
have
tells
to-
you. You should say, you gotta say to the client this, this, and this.
Should say, I'm canceling my vacation.
I am giving up
I have to
possibly
do a lot
other
of work in the
business.
first few weeks
Sure.
of this representation. What other stuff would you put in there, Perry?
Well, I think that it's truly so that they understand. I think this is all about transparency. Okay, this is about telling them in layperson's terms upfront what it is that you're giving up, in a sense, in exchange for the client giving up or giving you a fee that you're going to earn essentially upon receipt. I think to Jorge's point again, and with permission of a client, there was a case that came before the committee probably about 6-7 years ago where it was an immigration case, and the person, there was a complaint against the lawyer, and it said the immigration lawyer didn't do what they were supposed to do and did a bad job and didn't return my phone calls and all these things. And before they retained me, they responded to the committee, and they said, we did everything perfectly. We submitted the papers, we got the visa. In fact, we did everything so perfectly ahead of schedule that we even decided to refund $500 even though we didn't have to because we had a non-refundable retainer agreement. And sure enough, the committee went ahead and they dismissed the underlying complaint. And then they went ahead and they opened up a sua sponte investigation and said, please send us all of your retainer agreements for the last 2 years. And that's when they called me, and there was no defense to it. And the truth was, they had in their retainer agreement a non-refundable clause, even though the last line of the retainer agreement said, and by the way, we'll refund any money that we don't use. But it was that non-refundable language, which Jorge was just referring to, that immediately said to the committee, we need to look now at the rest of your retainer agreements, and it was a private, I believe it resulted in a letter of caution back then when we were sort of looking at things that way, that said, hey, you have to be careful because sometimes what you go into or before the committee for, in a sense, or what's been complained about, is not necessarily what you come out from the committee in terms of what they're actually looking at.
Sure.
Okay. So in this particular retainer agreement, needless to say, the woman who is paying the legal fee, the $250,000, she wants to make sure she's being protected. Who signs the agreement? Who needs to sign the agreement where she is paying the legal fee for the ultimate client, her stepbrother?
That's me?
Yeah, I'm asking you.
Okay, let me think, I don't do retainer agreements, however, she's a third party. The client is not her. She can be, third party can pay legal fees for that client, but the person paying the fee is not the client. And I assume she can say a retainer agreement, you're still gonna have to have a retainer agreement with your client. And the client has to know that this third party is paying the fee.
For sure.
Has to
So,
agree, because you may not want, if you're the client, you may not want somebody else to be paying your fee.
so,
And they certainly can have no control over the case, which becomes a problem.
so,
Put a special clause in that, a third-party clause, disclosing it, don't sign it, the third-party payer and the client.
you're gonna put that in the agreement, Perry? A statement saying the third party's making the payment?
Sure, under Rule of Professional Conduct 1.8F, as in fees. 1.8F says, listen, you can accept compensation from a third person, someone other than your client, but you have to advise the client that it's going to be happening in that way, that someone else is paying. And just generally, to the point the person was pointing out, the best practices is you're going to put provisions in the retainer agreement, which essentially say, listen, I'm accepting money from someone other than the client. I want to assure you, the client, no matter what, even if someone else is paying my fees, I'm not going to be influenced by that factor. I'm not going to listen. In fact, my actions, my conduct can't be controlled by that person. You're also going to tell the person paying the fees that, hey, listen, just because you're paying the fees, I don't have to listen to you. In fact, there is no attorney-client privilege. That's the most important aspect. Just because you're paying my fees, there is no privilege as between us. There's no expectation that I'm going to tell you. In fact, I can't tell you or reveal confidential information to you from the client. And essentially, you're just the person writing the check and nothing more than that.
So Connie, how sanguine are you gonna be if you're investigating this episode and you get wind of this agreement by which the lawyer whose firm it is basically paying for the fees? She's sort of a subject of your investigation, loosely speaking. The stepson or stepbrother is a target of the investigation. How sanguine are you that she's paying his legal fees in terms of how you're investigating that case?
I have no idea how she's paying those legal fees. I would be very, I would have a lot of questions about what the source of where the source of the money was.
Well, let's assume the source of the money is not ill-gotten gains. Let's assume it's clean money, okay? And you know that. Are you still bothered by the fact that somebody who's in the subject of the investigation is paying the legal fees for somebody else?
Of course, it would be, yes.
Are you going to do anything about that? You're going to make a motion to a trial judge and say, the guy we're investigating, his sister is paying for his legal fees, and we're also investigating her.
If I knew that, yes, I would.
You'd go to the judge.
Yes, I would.
Okay, Barry, we're going to bring you back into it. What would you do if that application were made to you that,
Well, what is the motion exactly for? I mean, what are you attempting to do?
Well,
Are you asking to what's your
well,
application?
I'm concerned about the conflict and about with that individual representing the target of my investigation.
and she might be a target too, ultimately.
I'd probably have a hearing and question each defendant, see if they're aware and understand the nature of the conflict, something like a Gomberg hearing, and go from there. And,
But she's not charged yet, right?
no,
Nobody
This
is charged.
hypothetical?
but even if they're not charged, one's a target.
Concerned
and-
about the conflict of the representation.
Right, so it would be, in the
and-
nature of a Gomberg hearing, to ferret out what each person understands, whether they know that down the road they may have to be a disqualification. If they're satisfied with that, then I might let it go forward, but they have to.
Supposing you find out that the agreement provides that although she's paying the fees and he is the client, that the payor wants to know what's going on in the case. That she's saying in the agreement, I want to know, as it goes along, what's going on in the case, and the brother-in-law, the potential defendant, says, I'm okay with that. You gonna do anything about that?
In other words, the payor.
In other words, the payor is a subject of the investigation, and she says, and it says in the agreement, that she is entitled to know what information is happening, what's going on in the case as it goes along.
Well,
I don't,
What about that agreement?
if the client actually says, no, I want, the third person, whoever the client wants, I want them to know about it, they're waiving the privilege, we wouldn't have a problem with that. That's happened. Where they say, I authorize, the
yeah.
person who's paying the money, I want you to tell her everything that I tell, keep no secrets from her. We won't have a problem with that. The
We
client
might not
knows
have
about it,
a
the
problem
client
as a
is.
disciplinary matter, but Connie may have a problem with that as a criminal investigator.
Well, that may be different, but certainly from us, not a problem.
Perry,
I
you
think
got a
the-
problem with the ethics of that agreement?
Not the ethics per se, so long as, I think if you take it a step further and you say, not only does the subject, or rather the target of the investigation, agree to share confidential information with someone who's paying legal fees and who also may be a subject. I think where you begin to get into sort of the thick water, or the deep water of it, is where there's a control aspect, meaning who is controlling the legal advice. I think what we're really talking about is whether it's a joint defense agreement or joint interest privilege, or a common defense or common interest privilege. I think that's really what you're talking about here, as opposed to a conflict or anything else.
This does not come up a whole lot at the Bronx Defenders.
You represent poor people who know legal fees, I got it.
But it does, the idea of a third party influencing, the sort of strategic approach of a lawyer and client in the case is like, that happens all the time, right? Like, I represent young people and they have parents, right? And their parents are talking to them and influencing them in the decisions they make. Sometimes I'm trying to, if the client allows me to share confidences with mom or dad, sometimes I'm trying to use mom and dad to try to influence client. Like, I think the question, and so whether that's like paying fees or relational or romantic, like that comes up all the time, it seems to me. And without, maybe there's something different about the payment and I just don't know about it because I don't live in that world, but that the idea that the mere pain alone raises the specter of that, I guess I'm sort of having trouble
But are they
seeing.
necessarily the target? The parent's not the
Yeah.
target. You don't have that.
What's
that
different
part,
here
that-
is there's somebody who's got, the woman's got skin in the game. She's concerned about where the investigation is going. That's why she's paying for the guy, because she wants to make sure it doesn't start pointing in her direction. Different than in the parent scenario you're talking about.
Sure, she's interested, but isn't the question ultimately the same, which is whether or not it's like a quid pro quo, whether the payment of it is dictating the strategy and therefore influencing the lawyer in a way that the lawyer has a conflict just because they cannot actually say that they are representing the interests of their client. Instead, they're now representing somebody else's interests because she's the target. I don't know.
Yeah,
This seems like a variation on the Michael Skeko case, where Sherman is representing Michael Skeko, and then after he's convicted, Robert Kennedy, who's the money man, who paid for defense, gets a lawyer to say Michael Skeko was ineffective for not pointing to
You mean the lawyer?
Skeko's brother.
the lawyer was ineffective.
Right. The lawyer was ineffective, but Kennedy, in other words, bought the defense, or at least paid Skeko had no.
Yeah,
money.
but Kennedy wasn't in the range of fire there. He had nothing to do with the event. He's paying for somebody else. He's not paying because he wants to make sure that the district attorney doesn't come after him.
No, but the ineffective assistance argument was presumably based on information that Mickey Sherman shared with him as the payor of the defense. And at some point, well, why didn't you go after the brother? That's, if you read the ineffective assistance decision that was overturned by the Supreme Court of Connecticut, that was the gist of the original decision, that his ineffectiveness was that he had reason to believe that the brother might have been a suspect.
Okay. Yes, ma'am.
These are two retainer agreement questions. They're not exactly on point, but are you saying that you need a retainer? If you have parents,
Can't hear in the back.
Do we have the microphone somewhere?
maybe,
Or why don't you just turn around, maybe?
you have parents who are paying your client's fee, whether your client is under 21 or not. Do you have to have separate retainer agreements with the parents and with the actual defendant is one question. Second question is, if you're charging an hourly rate and the client ultimately disputes that you needed to spend as many hours as you did, should you have some sort of, what is their recourse in a criminal case?
Well, if you, maybe the first one you'll address to Perry?
The issue as to the retainer agreement and whether or not you have to have one or two, I think Justine may have mentioned it, or someone else did, the idea that it's one retainer agreement. If you're having a third person take responsibility as to the obligations to pay, that has to be included in writing somehow so that the client is on notice as to what the limitations are or the expectations are, and at the same time, something in writing to explain to the person paying what the limitations are and the expectations are, sort of to avoid the theory that there's a quid pro quo of some sort in that regard.
Should they all be signing the retainer agreement? Is that what you're saying?
So the question is to signing and whether it has to be sent in writing versus a counter signing. Just say the easiest way to put it is, yes, it should be, under sort of a best practices, under 22 NYCRR 1215.1, which is the mandatory retainer agreement rule.
There's one in every class. Go on, go on.
Wait.
Parents want a child to know.
Let him first finish his answer, I'm sorry.
So certainly from a best practices, you need a retainer. It has to be in writing. Best practices says both should be signing it, okay? And both should be signing it to protect yourself in the end. That's the easiest answer.
Wait, but the only requirement is really you sign it with the
Correct.
client. From our point of view,
Right.
client signs it. The fact that the parents, are they paying, is that the?
Yeah, that's the assumption, I think.
You want them to sign, but they're not the client.
I'm sorry, you didn't finish, go on.
So I'm signing a retainer agreement with a client who's
Sue the
not
client.
paying, and with the parents who aren't paying, they're going to want something signed as well, and I'm going to want something signed as well.
Maybe, but I think what Perry was saying, you have to make sure that the parents know that they're not the client, unless the son or daughter agrees to give them confidential information, you can't discuss it with them. So once you do that, that's fine.
So this
But I'm saying
I
the
don't
real-
know at all. I'm sorry, go ahead.
No. The real requirements the best practice to have them all three signed, so everybody knows what's going on, but from our point of view, the one that matters is the client. You have to have it with the client.
Justine, this is something I don't know about at all. What kind of agreement do you have with your clients? It's not financial, but do you have a written agreement with them?
I give them my business card.
So there's no obligation for an agreement unless money is involved, Perry, is that right?
And, yeah.
Correct. Under 1215.1, if it's below $3,000, I did that again today. If it's below $3,000, then there is no technical legal requirement unless it's a domestic case or a family case, put those aside. But certainly from the best practices standpoint, either way, whether you're below $3,000 or not, you should have a retainer agreement. And it's just from a practical standpoint, you may not be able to do it right away, but you should have something in writing. And by the way, an email to a client constitutes a writing that lays out, and so it doesn't have to be always such a formalistic type thing, but there should be something explaining under the rules.
You can have a letter of engagement, but I think that, as Perry said, you should always have a retained agreement. The other thing is not that don't think of it as 3,000.
Right.
If at the beginning of the representation, you feel that it's gonna go, you pay me $1,000, but you think it's gonna go up to 5,000, then you still need, if you contemplate it's gonna go over $3,000, you should have a retainer agreement.
Does the letter
You should always have a retainer agreement anyway, probably.
Does the letter to the client say your parents have retained me? Please confirm that you're in accord with that.
Repeat the question so the folks are back here, please.
Like saying, should the letter to the client say that your parents have retained me, and are you okay with that? I think the letter, you shouldn't say they have retained me. They have paid your fee. You are my client. They have been told that you are the client. They paid it, thank you very much, but they don't control, whatever we're gonna do. They don't control the representation. But are you okay with the fact that they're paying? I think it's the parents obviously gonna say yes. My kids would definitely say absolutely yes.
Somebody else, this gentleman has a question here.
Oh, that's an interesting.
There you go, now,
The
Now we're
victim,
getting somewhere.
wow, that would be talk about a conflict.
It
might
depends.
come up for you,
Domestic
Justine, from time to time.
I mean,
Justine?
Wow.
we
that could
definitely
happen.
have complaining witnesses who want to pay our clients bail.
Well,
I mean, in domestic cases, that is not uncommon at all for a complaining witness to want to pay our clients
bail
bail.
is-
well, bail is different than
Right, but
paying.
that's the only example we
re-
have.
Well,
I've
they
never heard of
couldn't
that
pay
one.
you legal fees anyway, right?
Right,
You're not able to take that.
no.
I think it depends on how much is the legal fee.
No, she's not able to
No,
take the legal fee.
Justin,
The Bronx defenders refuse to take money except if you want to contribute to them, I assume, right?
Exactly,
I've earned
exactly.
back my good graces from Justina.
BronxDefenders.org, in case
There you go.
anyone has like some extra cash in their pocket they want to throw our way.
You just said that it could be informal. What about, just like a letter that's almost like in the form of a receipt, like, here's to acknowledge the $1,500 that you have paid me as a retainer fee for this case. Something
That's
like
fine. You're allowed to do letters of engagements or retainers.
That-
It's just that, you want to, if you make it too informal, because that's convenient for you and you're in a hurry, then they're gonna come back and say, they neglected my case because I wanted my lawyer to do X, Y, and Z. And you said, no, the client already told me to do X, and that's what I wrote in there, and sometimes not clear. So you want it to be clear. What is it that you're gonna do for them, and how much money you're gonna get paid?
A woman in the back has one?
If the disciplinary committee tells the lawyer, okay, we want to see all your client agreements for the past 2 years, why isn't that violating the client's confidentiality? I mean, very often the retainer agreement will say exactly what the work is. I'm hiring you to find the tax shelter for me. This is akin to, I represent doctors and nurses before the state disciplinary. And when you go there, if the doctor is affiliated with the hospital or the nurse works with the hospital, they will have patients' records laid out like stacks of phone books. And I know that they didn't contact the doctor or the nurse's patients. But why doesn't in the lawyer situation, why don't clients have the right to just not let the disciplinary committee know why they hired the lawyer?
Okay, that's an interesting question, but let's say in the case I think Perry referred to, which is we find one non-refundable retainer agreement, and then we say, and this happens quite often, we only do it in some situations. Like in that one, we want to see if it's just one-time situation that they issue a non-refundable just once, or did they do it in every other? But we will take care of the confidence. First of all, everything we do is confidential. So when they give us their 50 retainer agreements in the last 2 years, no one else is going to know anything about that. Only we know about that.
Confidentiality reposes in the client, not in the disciplinary committee. Just like for a doctor.
Maybe.
Confidentiality reposes in
But they're also allowed, attorneys are allowed to, in order to defend themselves, and now they're defending themselves against the charge that they put non-refundable retainers in every one of their retainers, or non-refundable clause in every one of their retainers. They're allowed to review confidences to defend themselves. So I see your point, but as a practicality, that will never be revealed. If it was a concern of the attorney, we would say, fine, then just give us the retainer agreements, delete the names of the people. We're just concerned about, do you have non-refundable clauses on all those retainer agreements? So as I understand your question, and we go through it, but as a practical matter, we take care of it. And the clients never know about it, and no one else knows about it.
The other-
So we're going, make a quick response if you
The other
want.
part
We're
is,
going off subject a little
sure,
bit.
these proceedings or these investigations we're talking about are deemed confidential under Judiciary Law 90 sub 10. So in that respect, but also generally speaking, the law in New York by most of the appellate divisions has been, as well as district courts in the Second Circuit, is retainer agreements are not considered in and of themselves privileged or confidential unless there's a last link doctrine or effect, and it's really evidence in a case. But generally speaking, payment-related information and retainer agreement information isn't considered privileged to begin with. So I think it,
All right, so let's go back to the hypothetical and change the scenario somewhat. So let's assume this woman who paid the $250,000 is unhappy with the lawyer. It wasn't a non-refundable, it was a minimum fee agreement with some of the pablum that Perry was going to throw into the agreement. But she says to a lawyer, she writes him a letter, "You're a crook, this $250,000 was ridiculous. I think the retainer is horrible. I think what you've done nothing for it. You've stole the money." And she hires a lawyer, and the lawyer writes a letter to her lawyer saying, if you don't pay up quickly for, say, $150,000, I, on behalf of my client, are going to the district attorney's office, charging you with larceny. How about that one, Perry?
I think that's the starting point. Is it a crime that the person's committed by keeping the money? Potentially, maybe.
Forget that. What about the lawyer's conduct?
The lawyer's conduct in threatening the criminal conduct or in threatening the
Threaten to go to the
prosecution?
DA. Hold on. We got a panel here. You're next year. Go on.
I think there's a problem. I think there's a problem with a lawyer going ahead and threatening criminal conduct. I believe it's under 3.7. When a lawyer says, if you don't do X, I am going to do Y, and that Y being I'm going to the district attorney's office.
Okay, so you're a smart guy. How are you going to accomplish what that guy was trying to do?
I'd probably write a letter advising the person that I believe that it's theft of funds, and as a lawyer, they should understand that this is criminal conduct, period.
What do you think about that, Jorge?
I don't like those letters, Perry, because then it looks like threatened criminal prosecution. So you have to be very, very careful. I wouldn't do it.
What if he says
You
we
are not
are
allowed
going to pursue all potential avenues of...
I don't mention anything criminal. So we'll pursue our legal options.
All legal remedies?
Well, then what can we do with that? If
Well,
there's no
what's
legal
your-
remedies, then we're not going to start saying, well, did that include criminal? Did that include civil? You certainly are not allowed to threaten criminal prosecution solely to gain advantage in a civil matter, and there are rules. In Connecticut, you can do it, not a problem. Not in New York. And certainly, if you do even what Perry was suggesting, we're going to look at it. We've had people saying, we're going to tell the tax authority or the Labor Department. Then we have to start going, well, the Labor Department has a criminal component. It's not threatening criminal prosecution. We've also a lot of cases where the attorneys actually flat out did it. We're going to tell the DA's office, tell county's office, if you don't give us about $250,000, we're going to tell the DA's office about it. My advice, if you're going to do it, just do it. Just don't threaten, just do it. Just give it to county. Then it's not a problem.
Well, the problem with that is, he's sort of, when he refers it directly to the DA without telling the guy, he's lost control of it. Then the guy needs to hire a lawyer. Maybe there's no money at the end of the day. He wants to stop the process. Let's assume there is an actual theft, and he writes that letter. No question about whether the guy earned the fee or not. Is an actual theft, and it's a definable sum. There's no question about it. And he writes a letter and basically says that you pay me what you owe me, and that my client what she is owed, not a dime more. Why should that be a violation? Why should that be coercion? Why should that be considered any kind of...
saying, pay me the money that my client's owed?
Well, what's ridiculous about it is, with due respect to the rule, that if my client himself wrote that letter saying, I'm going to the DA unless you pay me the defined sum you're owed, that would not be a crime. No, it would not.
Well, someone disagrees
He's
there.
wrong.
They may think it's extortion, but...
No, I am asking not me as a lawyer, as a layman, asking for that money for the exact sum and no more. That's not coercion. It becomes it's not extortion either. Take a look at the statute I have. Oh, Alan, you've been in this problem a little. Okay, we will look at the statute afterwards. That's not a problem. The problem becomes a problem if a lawyer is doing it on behalf of the client, and then you got to deal with the Torquemada over here.
I think Alan was my former boss, so I'll go with him.
For a moment
Supreme
until I
Court.
show you the statute. Let's assume,
was.
however, instead of saying going to the DA, what's in the hypothetical, I will go to the disciplinary committee unless you pay back my client what's owed. What about then?
Well, that's not prohibited according to the rules. However, we will look at it, and there's something called adverse reflex that some judges do not like it, but it has been upheld over and over. If your conduct adverse reflects on your fitness, integrity, et cetera, it can violate the rules, and you can be disciplined for it. And depending on the circumstances, it's not prohibited. The only thing that's prohibited is criminal threat and criminal prosecution. But we will look at it. Certainly, the one thing that is
Why would you
prohibited,
be looking about it if
because
there's no rule against it?
looking at because it could be adverse reflex. It can be so nasty that it, and perhaps in bad faith, while there's no exact rule against it, it could be adverse reflex on the conduct of the attorney. We will also, the one thing that we'll look at it, and we will discipline attorneys, is if the attorney says, you know what, I'll give you, client says, you didn't, I give you $2,000, you only earned $1,000, give me $1,000 back. And the attorney says, okay, I'll only give you the $1,000 back if you withdraw your complaint or you don't file the complaint. If there's a quid pro quo, we will also say adverse reflex. You cannot do a quid pro quo. You can say to the client, I hope that you would, here's your money. I hope that you would withdraw the complaint. That's not a problem. But you can't make it a quid pro quo. And that has been upheld over and over.
There you're looking to
Yeah,
add to this?
I think going back to this, it's actually Rule of Professional Conduct 3.4E, and that's the threatening, the threatening of criminal conduct. And that doesn't include, it doesn't say anything about grievance or disciplinary. I think the opinions, though, the ethics opinions in New York that have looked at this have sort of said, hold on, if you know that another lawyer has engaged, have actual knowledge that another lawyer has engaged in misconduct, then how can you threaten to go to the grievance committee if they don't do X, if they don't, for example, refund the money? Because don't you have an independent obligation to go in any event? And so I think that's where we sort of get into this thick sort of gray area of if there's an obligation independent of the payback, of the returning of the fees, then aren't you violating your own obligation, in a sense, by threatening and potentially not going if you have an obligation in any event? And I think that's where sort of lawyers get into trouble with sort of making that threat. I think this issue about, understand, I think it's a common misconception or misunderstanding. Clients who make complaints against lawyers, they can't withdraw that complaint, that grievance. It's sort of like going to the district attorney's office. You make a criminal complaint, you're going to the police, you make a criminal complaint. You can't withdraw it in a sense. There's still an obligation to investigate. You may choose not to cooperate. You may choose not to testify or show up or provide facts, but ultimately, the grievance committee has an independent obligation to investigate. So the whole notion of someone drawing a complaint is really a fiction, I think, in sort of...
But as a practical matter, we will give it, if it's a case where they say, my attorney's neglecting the case, they're not communicating with me, and now the communication becomes wonderful, they have a great relationship again after the complaint was filed, and they say, we want to withdraw the complaint, yet we don't have to. We're not bound by it, and it says that in our rules, but more likely than not, we will say, okay. If this happens quite often, client says, my attorney stole my $100,000 settlement, and then, complaint comes in, they got paid right away, or they got paid, a month later while the complaint is pending. We will say, that's wonderful, but we want to see where the money was before you gave it to the client. And we're not going to just withdraw that because that's, involves $100,000. We want to see, and I've had many attorneys who say, well, I pay the money back. Shouldn't the case be closed? And I always go, sure, just show me where the money was before you gave it back.
Show me the money.
And they were disbarred, by the way. They all lie, unfortunately.
Alan, to respond to our last, Le Bernardin, it's a very good French restaurant. It is an affirmative defense to a charge of extortion that the person is actually owed the money. We could look it up later. Le Bernardin, 250 witnesses? We'll see. Okay. Who's got a question?
The portions are very small there.
Fair enough. Fair enough. Anybody have any questions on either of the questions that we've gone through? Or if folks want to, yes, this gentleman does.
How do you treat when inmates file complaints with their lawyers? The inmates.
The question is inmates filing complaints against their lawyers.
We look at them like any other complaint. The one thing is, that usually falls in the category of, you know, I
Excuse
pled
me, the
guilty-
panel is
Sorry.
still in session here, please. Let's not disrupt the program, thanks.
Usually the complaint is, you know, I pled guilty to robbery and second degree, I'm doing 2 to 6, whatever. And the district attorney, the judge, and my attorneys were all conspire against me, and I'm totally innocent. I mean, those you can tell right off the bat. Nothing else. No real allegations or anything. We'll look at it, but those cases, for the most part, are given to me, and I'll close them. I don't think an attorney should have to answer that.
Go back. Why don't you wait till he brings you the mic, please?
Just want to know if there's a link where I could get a copy of a ethically correct retainer agreement. Do you have one online somewhere?
If
I'm
you,
sure there are, but I wouldn't have, but.
if you call
Perry would know it.
212 NY Ethics or 718
Sure.
NY Ethics, I'll give it to you over the phone.
Sure.
Do you have that copyrighted? That,
Yeah. And by the way, you can all any of the county associations, if you have any ethical questions, any of the bar associations, whether it's the city bar, or New York County Lawyers, the Bronx, the New York State Bar, they'll all be happy to help you with
What are
any
you taking
ethical
the guy's
questions.
business away?
Or you can go Perry.
But in all fairness, no, Jorge, if you also go to the first department's website and the second department's website, there are some great resources that are now available there in terms of Part 137 fee arbitration, in terms of retainer agreements, and the rules themselves. In the last couple of years, they've done a great job to provide some of those sources online for people to be able to use and refer to.
I have a question. Is it proper to include in your retainer agreement that if the services unexpectedly change, for example, I represent a client, there was a 50-count indictment, and then next thing I know was 525 counts. So that gave me, obviously, time to pause and indicate to the client that due to the unexpected nature now of the case, I am seeking a new agreement. My question is, should you just include it in all your agreements because you may not know what the circumstances will, or just leave it out and then wait until that event happens?
I think, you know, Perry probably knows more retainer agreements than I do, but you probably would want to say it right off the bat, that if it changes, we may have to alter the retainer agreement, you may have to pay different fees. I don't know how Perry feels about that.
No,
I think it's a good
100%. In
idea.
the same way, carving out, it does not include appeals. I think you try and sort of carve out for the smallest piece of territory in terms of what you're representing them on, and to create or include a catch-all provision that says, should the circumstances change beyond this, matters that are beyond the scope of this, then I, as the law firm, reserve the right to go back and to revisit this issue, et cetera, et cetera. I think you have to lay it out in some form or another to make sure that should later on the circumstances change, you're not in a fight with a client over increasing fees, et cetera. So I think it should be there just as a matter of course. But it also has to be balanced with, you provide a client a 7-page, single-spaced retainer agreement, and they may balk and walk away from it. So I think there's that also balancing on the business side with the ethical and legal and practical.
525 counts, what the hell did the guy do? Don't ask, I got it.
What's the chief difference between a criminal defense or a criminal case retainer and a civil case retainer?
Oh, God.
You ask for a lot more money up front?
Well, for instance, in a civil case, you have to have mandatory arbitration and tell the clients that if there's a fee dispute, they have a right to mandatory arbitration. There's no such thing in a criminal retainer. You can voluntarily go, but they don't.
You can voluntarily go.
You can voluntarily go, but there's no, it's not mandatory.
Please join me in thanking the panel.